thank you so much for joining us today at this Physicians for Human Rights webinar with our guests from Public Counsel to talk about writing expert declarations. So let me first introduce our two experts who are here to share their experiences and their expertise. Physicians for Human Rights Senior Medical Advisor Ranit Mishori is a professor of family medicine at the Georgetown University School of Medicine and director of the department's global health initiatives. Her career includes academia, scholarship, clinical care, mentorship, and leadership roles in public health, global health, medical education, care of underserved populations, and human rights. She has been at the forefront of international and national discussions on the health consequences of forced migration and associated human rights issues. Dr. Mishori graduated from the Georgetown University Medical School and Providence Hospital Family Medicine Residency. And she also has a master's degree in international health, the disease control and prevention track from the Johns Hopkins Bloomberg School of Public Health. Also joining us is Mark Rosenbaum, who is the director of Public Counsel Opportunity Under Law. He joined Public Counsel after 4 decades with the ACLU. He's argued 4 times before the United States Supreme Court, more than 25 times before the 9th and 2nd and 6th Circuit Federal Courts of Appeal, 3 times before the California Supreme Court, and before the United States Court of Military Appeals. He has been principal counsel in landmark cases in public and higher education, voting rights, poverty law and homelessness, racial, gender, class, and sexual orientation discrimination, healthcare, immigrant rights, foster care, and criminal defendants' rights. He currently teaches law at the University of California, Irvine's Law School. He graduated Phi Beta Kappa from the University of Michigan and from Harvard Law School. So with that, I will open up the floor to our panelists. Thank you so much for joining us.
Thank you.
Thank you. Thanks so much, Catherine. And thank you everyone for joining us this afternoon on such a short notice. And I know everybody is incredibly busy given the situation in the country and around the world. The webinar today was conceived following a couple of weeks of pretty chaotic weeks where we were seeing a flood of requests reaching me and Physicians for Human Rights for expert declarations. These were parts of efforts to get immigrants in detention and other incarcerated individuals out of jail as the looming coronavirus pandemic was threatening correctional facilities around the country. Those detained in them, the staff working there, and the neighboring communities. So about a week or so, or 10 days ago, I was working on writing my 3rd or 4th declaration, and when I was approached by Mark Rosenbaum, our speaker today, who helped usher me very thoughtfully through this somewhat confusing process of writing declarations for emergency litigation. So I know many people today on the webinar, some of you have been working on your own declarations and you may have questions or maybe in need of some advice. So this is what we're going to do today. We will review the need for these declarations, we'll review the process, and we'll touch upon best practices to some extent. You will have an opportunity to ask questions through the Q&A button at the bottom of the screen. And we will also, we are recording this webinar, so if you know colleagues who can't join today, we can send the link afterwards, and we're also going to send a summary and a tip sheet after the end of the webinar, so everybody has all that they need to write successful declarations. So I'm going to turn to Mark. Welcome.
Thanks for having me. Thanks for everybody for participating in this.
So as we talk about the medical legal collaborations, can you just tell us a little bit, and you shared a little bit before the webinar started, about what is going on right now in the country? What are some efforts that are underway, and what have we seen so far in terms of success stories, failures, or anything in between?
Well, by and large, as you know, and as I think the participants on this webinar know, the response in most areas with respect to individuals who were incarcerated, both civilly in, say, the immigration system and in the prison system, the initial response was to ignore the national emergency and not pay attention to the characteristics of this deadly virus. That precipitated a stream of lawsuits from the East Coast to the West Coast. And that has led to more agencies in charge of these facilities releasing people on their own. In terms of the lawsuits, by my count, there have been something like 20 plus lawsuits filed regarding prisons and regarding immigration conditions. By my count, virtually every one of them has resulted to one degree or another in the release of individuals. Some of those are individuals who are high risk. Some of those are just individuals in powder kegs before the actual explosion takes place. I know of two cases where the courts came out otherwise. One was an early case in the state of Washington. I think the reason there, the judge said, well, that nobody here has yet been confirmed as having the virus. We know now, of course, that that's not a standard to talk about risk. And there's another case in Texas, and I'm not familiar with the details. But the reality is that virtually all of these cases have succeeded, and they have succeeded because of the power of the client statements, the community statements, and especially because of the power of the expert declarations.
Mark, so when we talk about expert declarations, I think many of the, I suspect many of the participants here, many of whom are members of the Physicians for Human Rights Asylum Network, were pretty much all experienced in writing affidavits on behalf of individuals as part of their asylum proceedings.
Yes.
What is the difference? What are expert declarations in situations like the ones that you're describing? So what is the purpose, and what is the difference between a medical affidavit, a declaration, and a supplemental declaration?
Okay. Good and important question. The first point is the difference between an affidavit and a declaration is technical. When you sign an affidavit, you get it notarized. It has to be formalized in that sort of way. That is not a requirement for a declaration, although both have equal weight in the courtrooms that we're talking about. So a declaration simply says declaration of so-and-so. It's a series of numbered paragraphs. We'll talk about the contents a little bit later. The individual signs it, attests that all the statements are true, dates it, and tells the location. That both affidavits and declarations then are a substitute for live testimony, so that a judge is receiving these declarations and he or she will not actually hear from the person who submits it, but will treat the declaration as if it were oral testimony. And in the matters that we're talking about, emergency matters, matters where life and death stakes are involved, there's not time to have a trial. And that's why the relief that's being sought, it's what's called injunctive relief, ordering a defendant, like the government, to do something right away. And so all the testimony in those cases typically come in through the written declarations or the written affidavits. You asked me about amicus briefs as to
not yet, but that's the next question.
The difference between an amicus brief and a declaration or an affidavit is this. An amicus brief is a brief. It is a legal argument that is supported by factual statements that are attached. Amicus literally means in Latin friend. It is a friend of the court. It is submitted by a group or an organization or an individual or a set of individuals that have special stature in front of the court. So if you had epidemiologists, if you had individuals who are used to working in areas where individuals are incarcerated, that's a powerful amicus brief, and a court will pay attention to it, even though it's not submitted by a particular party. Usually an amicus brief takes a position in favor of one party or another. But an amicus brief is argument. A declaration is actual testimony. It's actually actual evidence. It becomes the record upon which the law is decided.
And so if somebody is approached about signing an amicus brief as an individual, what are some issues about deciding whether you need to involve your employer in, or telling people that you need to, that you're about to sign an amicus brief? Is there any issue that needs to be considered? Because when I was asked just last week to participate in writing an amicus brief, I was told that my employer, so be it the university or Physicians for Human Rights, was that I should notify them because there's a risk. And what is the risk?
Well, there's no risk that I know of. I mean, there's a risk. Let me answer your question first, and then we can talk about whether or not any risk exists. Certain organizations may have certain policies. They may say to the doctors at PHR, before you sign your name to anything, because you're so closely associated with us, we want to give clearance to make sure that you're not stating anything that is offensive to our policy. But short of that, an individual can sign, and what we typically do is we put an asterisk by their name. So we might identify you, Ranit, as an individual who is a member and an officer in PHR, but you would say, I'm just putting that down for identification purposes only. There's no risk legally unless you misrepresent that you're speaking on behalf of the organization. And I frequently tell individuals, you know, if you can speak on behalf of the organization, great. And if you can't, just simply say, I'm speaking in my own personal capacity. Here are my credentials. I'm associated with a particular organization. But in this instance, because of time constraints or whatever, I'm just speaking for myself based on my expertise.
Great. Mark, one of the cases that I worked on with you was a case where you represented two individuals. Yes. And I worked on other cases that were class action suits. So what is the difference between them and in terms of what we bring as medical or public health experts?
Great. Well, we should first say that the two individuals on whose behalf you submitted the declaration, they are out. They were released the next day. They are in much safer circumstances than they were. And I don't pretend for a moment it was because of any lawyering. It was because of their declaration and your declaration, which the court relied upon heavily. The difference between individual actions and actions on behalf of a class is that a class action speaks for an entire group that is defined by a common characteristic. All individuals who are presently housed in Rikers, all individuals who are presently housed in Adelanto Detention Facility, all individuals of high risk according to CDC standards. There is a common characteristic that defines the class. And if the court recognizes it, then those individuals receive whatever relief that the court gives en masse as a group. In our case, we didn't have time to get a class action, and these individuals were in desperate straits, plus they had been brought in circumstances that greatly heightened their danger to them. And so the goal was to get them out as individuals themselves. Sometimes you hope that individual actions will lead, say, the government to do the right thing with respect to all detainees or all those who are incarcerated, but that certainly hasn't been the case here in most instances.
Great. So let's try to turn from the sort of big picture of what type of litigation this was to something about us, people on this webinar, most of whom would be working as public health or medical experts. So what is an expert? Who is an expert? What is it? What kinds of credentials are you looking for when you seek some sort of a partner in a litigation like that?
An expert legally is simply a person who has specialized knowledge. It could be someone with a PhD. It could be someone who has worked in a particular area for a meaningful length of time so that they have accumulated a body of information, a body of experience. It could be simply someone who is more familiar than the average layperson. What I'm looking for in a case like the one that you worked on is to say to a judge, this is an individual who knows her stuff, who can answer the sort of questions that you need to answer in order to address the legal issues that are underlying the case. So your credentials as a person who has dealt with contagious diseases, a person who has dealt with epidemiology, a person who has dealt with incarcerated populations, all of that was germane to what the judge was looking for. Does an individual have to have all those qualifications? Absolutely not. The individual simply has to be in a position to answer better than a layperson particular questions with respect to particular issues that are raised. You don't have to answer every question on a case. Just before we came on, I watched Peter Navarro, who is an economist, talk about what are the appropriate cures for this virus, particular treatment for it. He's not an expert. He has no expertise in any area. Yeah, it does show. He has no particular expertise in that area. So the question each of your participants should answer is, do I have any particular knowledge based on my experience, based on my training, based on my background that will help me answer the questions that are important to this case? So to give an example, in our case, there were two principal legal questions. One is a doctrine called state-created danger. Does the state, does ICE, does the government put an individual in a more dangerous situation than he or she was by virtue of their actions? So when ICE picked up our individuals who were in the community and were practicing social distancing and isolation, and takes them into a crowded facility where there's not testing and where there's not any of the sort of procedures, you're equipped to answer that question because you know what the particular protocols. Another legal question was, all right, we have an individual in a facility. Here are the characteristics of that facility. What does that mean with respect to the incidence, treatment, spread of the disease itself? And so, again, you don't have to be a all-purpose expert. You can answer parts of the question. And the last thing I want to say to you with respect to that is, one of my major issues with experts like yourself is that you're too damn modest. This is where you show your stuff. This is where you persuade a judge. That's why I asked you for your CV instead of your resume. The question that each of your participants should answer, absolutely immodestly, but truthfully, of course, is, why am I qualified to answer this particular question? Doesn't matter what your political views are, doesn't matter what your personal philosophy is, but why does my training, experience, and background permit me to answer the questions that are being presented to me?
So, for example, if we have, and I've been asked this question this past week, if the physician is somebody who may have finished their training, within the last 5 years versus somebody who's had more than 20 years, do you think that's going to be looked at by the judge as having fewer qualifications? Are they less credible in the eyes of a potential judge?
Look, commonsensically, the more experience, the more training, the more background, the better. But someone who's out 5 years is perfectly qualified to answer the sort of questions that we're talking about. We're not talking about some sort of experimental treatment that the individual may have little or no knowledge of. We're talking about basic principles that underlie immunology, that underlie how you deal with this. And I think it's important for an expert to say that. I think it's very important for an expert to say that, I'm well qualified and here are my credentials, but the issues that we're talking about, whether or not social distancing should be practiced, whether or not this facility where there are 8 people in a room that ought to house maybe 1 in terms of basic principles, you don't need 30 years of experience in order to present an opinion. So, of course, more is better than less, but we need everybody in this. And I think the more we can say, this is common sense, this is immunology 101, this is the first thing you learn when you study this virus, that's more than sufficient.
Great. And I'm seeing a question.
And one other thing I want to say regarding that, if I ask you your basis and you state, look, here's an opinion by the leading immunologist in the country, by the leading expert in the country, and I agree with that, that immediately boosts your opinion. So even if your experience is limited in some sort of relative way, by the character of your analysis and the sources that you rely upon, you can demonstrate that it's not just your experience. One of the questions I asked you is there a single public health specialist in the country of any degree of experience who would support the way these individuals are detained in Adelanto? So you can boost the integrity and the credibility of your answer, not just by your experience, but by the sources you rely on.
Great. And there's actually a related question here, and I'm going to read it out to you. Regarding expert credentials, any thoughts on attending physicians, meaning more experienced physicians, versus resident physician status? So residents being trainees still. And the person is writing, I'm currently working on an expert declaration. I am in my second year of my family medicine training, which is sort of senior resident.
Well, first of all, thank you for what you're doing. It's going to make a big difference. And again, is there a difference? Of course, there's a difference. But the fact that you're there and you see this firsthand and you're working with additional experienced persons under their supervision and you're relying on textbook knowledge, all of that should be presented. So I think your instinct is right. Be somewhat defensive about it, but absolutely we need your assistance in it, and just strengthen the integrity of what you're saying by the other sources. But what we're looking for is exactly what you've got, and that is on the ground experience in terms of understanding this virus and understanding the circumstances that will ameliorate or worsen the likelihood of its spread.
Great. Mark, what are, speaking of credibility in general, are there any things or is there anything that would give you a red flag in terms of, oh, I don't want to work with this person, or anything that might affect someone's credibility in a negative way?
I'll answer that this way. If the individual is stating political or personal ideological views, that may disqualify them from having certain credibility. That doesn't mean, like everybody else, that you don't have views, but those views should have no part in terms of the expert conclusions that you're reaching. By the same token, this is a little bit digression from what you're saying, all I ever ask from a declarant is to tell the truth. But I do say, this is not the time for loose emails. This is not the time for catty statements. Not that individuals would necessarily do it, but this is, you're a serious scientist and you're talking seriously about it. Another question I have been asked is, well, what if I think that another expert has written things powerfully and has laid it out? Can I just pick that up and use that in my declaration? And the right answer to that is, well, of course you can. In the same way, if you were writing a peer-reviewed journal piece, you would quote from other journal pieces or other experts whom you represent. But you talked about earlier about what are best practice guidelines. And the best practice guideline, if you're going to do it, just don't cut and paste it. Just say, I have read the declaration of Dr. So-and-so. I am familiar with that individual's qualifications. I agree with the conclusions, and I think they're applicable to the particular situation that I'm addressing in the following ways, so that no one can say that you're taking it out of context. So failure to do that may have some marginal negative effect, but we're talking about life and death stuff. And again, we're talking about basic principles. That's what a court's going to want to know. What are the basic principles to be applied here?
Going back to the issue of not turning the declaration into a political statement, there's a related question that I wondered about, and also one of our participants just sent, is what if many of us are obviously a little bit biased and want to help certain populations, and we may have expressed ourselves in maybe not so professional ways on social media. Or is anybody from the opposing team, as the judge, is anyone going to look for our statements on social media? And is that, how careful do we need to be? And is that going to look biased? Is that going to make you or anyone else think less of us as experts if we've expressed ourselves in such a way on social media?
I don't think anybody's going to think less of you if you're a human being and you've expressed your views on matters of great public significance. As long as those views are grounded in your professional judgment, as long as I can make those sorts of distinctions, if you feel like such a record exists, I would still have no hesitation about asking you to serve as an expert, but I would say to you, take a special care to make clear that your expert conclusions are grounded on clear scientific data and clear scientific findings themselves. I guess I would say, I'm, as a lawyer representing civil rights, I'm very careful about statements that I put out publicly under certain circumstances. But goodness, you are an expert. You make those credentials clear. I would say to you probably, who else in your field has spoken about the risk that we're talking about here, the medical scientific risk? I might ask them to join it, but you're a human being and you're entitled to have views, and there's something wrong if you don't have a view in terms of what's going on, but just make clear that you're grounding it on scientific fact.
Great. So let's move on to the more practical. I mean, this is all very practical, but how do you actually write a declaration? What is it that you want to see when you call somebody like me or other people and you say, I need you to help me with a declaration? So what do you expect to be in a declaration?
Okay. A declaration is a set of numbered paragraphs. I'm often asked about how long should a declaration be. It should not be a journal piece because a judge is unlikely to read it or to understand it. On the other hand, it should not, in my judgment, it should not be a one-page set of conclusions. It should be detailed enough that the judge understands your qualifications, understands your reasoning, understands the facts that you're relying on, whatever assumptions that you're making, and that it's a clear narrative. The worst thing is skimpy declarations that really read like a set of pre-written conclusions. I say to an expert, here are a series of questions that I want you to answer. I never say these are the answers I'm looking for, because I just want the truth. And I want those questions laid out. And different lawyers are going to tell you different things, but the declarations I submit will often start out with, my name is Dr. Ranit Mishori. You state your qualifications. You state why you're an expert in the areas that are specific. You attach your CV, and then you say, I have been asked a series of questions. The first question I have been asked are, what are the appropriate circumstances, if any, that an individual in a community at this time, so as not to increase that individual's risk of contracting or spreading the disease. My understanding is that a particular individual was arrested under the following circumstances. I have read that individual's declaration as to those circumstances. I assume this to be true for purposes of my answer. And then I lay it out in not overly long paragraphs, but paragraphs that have bite in terms of the answer that I give. What are the questions? If a lawyer doesn't say to you a set of questions, then the expert should say, what are the questions that you want me to answer? You lay them out at the beginning of the declaration. You organize your answer so that you have articulated. You cannot lay out enough reasons to support your conclusion. Your conclusion could be based on, as a resident, what I have seen firsthand. It could be based on your training. It could be based on CDC directives. It could be based on the knowledge about how this virus operates. And you articulate all of what that is. Set of questions, your answers, your reasons from your answers. And you can work with the lawyer to outline it. So this is where I talk about the incidents. This is where I talk about the likelihood of spread. This is where I talk about the comparative risk. This is where I talk about appropriate sanitation conditions. You're not writing a paper for a journal. You're writing a paper for a judge who is not well versed in this area to understand, which is the other thing that I want to emphasize. The judges who we have had in these cases want to do the right thing. They want to apply the law correctly, but they're not experts. They've watched television. They've seen conflicting newspaper articles about it. You need to set them straight, and you need to assume that they may not have that basic knowledge, and you need to go back as a primer to lay out what a virus is, how a virus operates, how this virus is different, in order that they fully understand.
So not using medical jargon is a critical piece here.
You can use the medical jargon, but you've got to explain the medical jargon. If you have a way, I mean, imagine you were explaining it to your partner. Right. You might use the jargon, but then you'd explain what you mean. It's like I said, here's an amicus brief, here's what it does. It's a friend of the court brief. So, you don't have to dumb it down in ways that take away the characteristics of what you're talking about. When you were talking to me, and I may get this wrong, you talk about two not. Is that what that was?
Are not.
Okay, are not. So it shows you how well I learned that. But I didn't have a clue what you meant. You need to use that phrase, and then you need to define it, and then you can continue to use it throughout.
Great. What happens is in the case with the declaration I worked with you on, where it had to do with a very specific detention center that I've never been to. Yeah. And many of us have been asked to write declarations for people in Louisiana and in Georgia and in Virginia and other. So how does one traverse this type of situation where you are never there, and can you still make a comment, an educated comment about the conditions in that particular situation?
Yeah, that's a super question. If someone in Seattle had never ridden the New York subway, they still could offer an opinion as to whether it's a good idea to run that subway under normal conditions right now. So that's where you lay out your assumptions. That's where you say, my understanding is that the detention center does not permit all of the detainees to be social distanced. My understanding is that there are individuals who may be asymptomatic who are in there. My understanding is this is the protocol that's being utilized, which means you have a job too, because we're just lawyers and we know what we've read in papers and seen on television in our conversations, and we try to do our homework. The first thing I said to you, which is a good idea, is send me everything you want me to read so that I can talk your language. And if you have written papers or you have materials you want me or the lawyer to look at, get them to me. But the basic answer to your question is state what your assumptions are. Don't worry that you haven't been in the facility, but explain what conclusions you have based on those assumptions.
And how much is it okay to ask the lawyer to help you with getting information? For example, you helped give me some information about Adelanto, and other lawyers have given me information about other detention centers. Is it okay to have that, or
absolutely,
are you the lawyers?
Absolutely, because what the judge wants, it's not a game. I mean, this is life and death. It's not a game. And if you say to me, Mark, it would be helpful if I had the following information, get it to me, and then validate to me how you got that information, and then use that as an assumption. Of course. You can also qualify your answer. You can say, I don't have particular information with, what's been done over the last 3 days. But absolutely, you can ask the lawyer to do it. And you should test yourself as to whether or not you think that information you've obtained is reliable or otherwise stated what it is. But I'm here to be your servant. And you tell me what you need, and I will do the very best I can to get it for you.
Great. Is there anything that absolutely shouldn't be in, you already mentioned political statements or anything that's that would be considered biased. Anything else that shouldn't be in a professional declaration or expert declaration?
Yes. The first answer to that is, if you were writing a paper, if you were for publication, the same question, is there anything you shouldn't put in there? And if you wouldn't put it in a publication and you wouldn't put it as a basis for explaining something, it shouldn't be there. There's an objection in the law called speculation. There's a line between asserting an opinion and just wild speculation. If you're not confident that an expert can offer an opinion, and you think you've crossed a line into, this is all speculative, don't put it in there. But other than what we've talked about, you ask the question, you answer the question, you talk about the facts that underlie it, and then those expert opinions that you have based on your experience that describe it.
Great. I want to talk, there's a question here that I think would be interesting to other people, and I'm going to read the question, and then also I can answer it, and then you can answer it perhaps even better than I can. But the question is, my work with PHR has been doing asylum evaluations, documenting specific psychiatric syndromes in the applicant and how they support his or her claim of trauma. The declarations you describe here seem totally different, not talking about the individual's medical status, but rather describing the circumstances of every person in the facility. Is that correct? So I can tell you from my experience that I've done a few declarations that talk about very specific individuals with medical conditions that make them, render them very, very high risk for a coronavirus outbreak, should it happen, and for having severe repercussions if they were to contract the disease. So absolutely, there are cases where you're asked to render your medical expertise or psychiatric expertise about specific individuals and their medical conditions. The difference is you don't get to examine them. Is that correct, Mark?
That's such a good question, and let me answer that in a few ways. First of all, I have been talking more generically, and I see that as your baseline answers. That is, these are the answers that you would give if I didn't know anything in terms of the characteristics of the individual, or not much. Now, notwithstanding what I said about speculation, if you were to say to me, look, I don't know who's in this facility, but if there are individuals who have diabetes or autoimmune problems, or are being treated for cancer, or are of a particular age, whether or not they are the detainees or the people who are working there, then my opinion is this. I maintain my baseline opinion, but I increase it so. So the asylum example is a really good parallel, because you are looking at the particular circumstances and what will happen to that individual if that individual is returned to a particular country. So, the way I think of it is, what is your baseline answer, giving the characteristics of this disease, being one that is asymptomatic, we don't know for 14 days, whatever the period of time is, what it is. But if you say, it's a question that a good lawyer would ask you, but you could ask me, and you would say, are any of your people over 60 years old? Or any of your people have those conditions? And if I say, I don't know, you can ask me to get the information, but you could also say to me, that facility needs to know that information. The arresting officer needs to know that information. So baseline is right, but if you can get specific facts, or if you can consider what would be the consequences of those facts, that should be down there as well.
Yeah, and then I can tell you that when I did a declaration on behalf of 16 individuals, I asked for their medical records, which I wasn't provided. Nevertheless, what the lawyer did give me was statements of these 16 individuals, each of them describing what their medical situation was, what their medical conditions was, and I was given an opportunity to go back and forth and say, well, when they're talking about they have diabetes? Do they know what their hemoglobin A1C is so that I could determine is it controlled or uncontrolled? So there's some back and forth that
there is. And in early on in your declaration, you should state what you have reviewed. So, we submitted you the declarations of the two individuals. You asked us to ask certain questions of their families and them about that. We presented that, and you should reveal it. But, in every one of these questions is a nugget of an answer. Because if you, as an expert in this area, want to know their medical histories, then certainly law enforcement should want to know that too. And before anything is done at Rikers or anything that is done in Adelanto or any facility across the country, those are the questions that should be asked. And a good section in your declaration could well be, if this has not been done, this is not in accord with accepted professional standards, with what professional standards would require in those circumstances. So if you're troubled that you don't have the medical records, then Rikers or Adelanto or any facility ought to be really concerned about that.
I have a related question to this. So I'm going to read out the question. So how is this, or why would this be any different than doing a forensic evaluation in terms of risk to the incarcerated clients? Do they have to prove that they have somewhere to go once released? I know this is a question that I've been asked multiple times this past week. What if we release them and then it turns out that they're infected or they're currently asymptomatic? How can this be discussed? How can this be argued in front of the judge that it's a good idea to release somebody who may be sick back into the community? So is there some sort of a need to prove that they have somewhere to go?
Often these cases involve risk analysis, and that is an important part of it. We presented testimony that when our individuals were released, they were going to be put in isolation and for an appropriate period of time, and that they would be maintaining social distancing. I think that's an important question. Talking to you like a lawyer for a moment, if the government has taken these people into custody where they may well have been exposed to the disease, it's my position as a lawyer, which is correct, that the government has a duty or an obligation to make sure that those individuals are appropriately quarantined, appropriately safe. Otherwise, it's a question of medical ethics in terms of weighing and evaluating what the difference is. I have a totally unrelated case involving persons who were picked up in Skid Row and then taken into jail before the virus hit. And we were successful in arguing that before the county jail released them, because the county jail had them, they were exposed to conditions, they had to be released in a way that would maintain their safety and preserve it. But for this matter, I think that's a really important ethical question, and I think that's one each doctor should answer according to the appropriate standards. But if that facility, look what's happened at Rikers. If that facility is a tinderbox, a death trap, then I think you say, look, they've got to get them out of there, but they've got to get them in a place where, we asked for our clients that they be taken, tested, kept somewhere for 14 days, and the government said, no, we're going to go back on that issue. So there's serious questions, and I think that it's an appropriate concern to take place. But like I said, the places we've been talking about, they're tinderboxes, and it's hard to imagine that they're more congested. We talk to the families, and we get assurances, which we then monitor, that the people will be maintained safe according to CDC standards.
I want to move on, and then I just wanted to mention that at the end of this webinar, we're going to send a sort of a de-identified or a template of a declaration that you can, or several, that you can use as a model for writing your own declaration. And again, is this a problem, Mark, to
No, it's not a problem at all, because it's not a problem at all because individuals, you're not lawyers, and you don't know what a template looks like. If the answer was that someone just copied everything that was written and has nothing individual to offer, well, that obviously would impugn the integrity of what that is. But there's no problem, with respect to setting out basic templates to explain what's going on. I also want to say that any person in your audience or any person that they know is free to contact me. Just email me with particular questions. I'll sign you up as an expert in our case, the qualifications. But more importantly, these are serious issues. You all are saving lives, not just of the individuals, but of the communities that they come from. And I want to do everything I can to answer any question, which raises another point, and that is, you said to me, and other experts I've dealt with always say to me, have you talked to so-and-so? Have you talked to other individuals? If there are individuals who you think know this field well and has something to contribute, the lawyer whom you're working with wants to know who they are. And remember I asked you, are there other people you're talking to? And you set up some introductions. And that's how we, expand the base even further.
So speaking about, there's a question here from one of the people who are listening in. Are there opportunities, since we're talking about this, are there opportunities for us to get involved on current declarations being written?
Yeah.
And so how does the lawyer find the medical expert, or how does the medical expert find the lawyer?
That is such an important question. I just got through, I'm working on a case involving the families that were separated and getting them access to mental health treatment, to families that were separated at the border. I worked on the DACA case, which also had experts. We don't know one another well enough, and shame on us for not doing that. We need to know each other's networks, and we can't wait for an emergency for me to meet who you are. So the answer now is to use your contacts. You're probably one or two persons removed from people who are working on these cases. We're overloaded, as you are overloaded with work getting forward, but we also have to develop better networks so that we're not meeting each other for the first time when these crises do. But for now, all of us are just one or two persons. It's one of the lovely parts of what we do is we're a community, and we know one another, and we know so many people who are doing heroic things. So we can quickly get you in touch with people who need you desperately.
And also I'm seeing one comment that MCN has a project titled Medical Review for Immigrants. We will link a pro bono attorney with a clinician who will write the letter of declaration based on a review of the medical records. So sounds like this is a very good resource.
It is, and this relates to an earlier question I don't think answered completely. Sometimes an expert will say, look, Mark, I don't have time to write that declaration. And what I will say to that person is, let me interview you. Let me interview you thoroughly. Let me read what you have written. I will do the best I can to be your translator, not to talk like a lawyer, but to talk like you. Then I will give it to you. And I will say to you, I don't want to take anything out of context. I just want the truth. I'm glad to do a first draft based on my understanding. You make any and all corrections that you need to do in that. And that's a perfectly acceptable way of doing it, as long as you can say with 100% guarantee the final product represents my views as that. But sure, that's a great source. That's an absolute great source.
Yeah, and I remember we did that for the Supplemental Declaration, which came at like 10 p.m. Eastern time, and I said, I can't write anything. And you talked to me, and the next day you sent me
and they're your words
draft.
that are there. So what's a supplemental declaration? You submit a declaration when we file seeking the release of the two individuals. The government files a declaration. I just read right before we got on, the government sent a declaration in our case, which doesn't mention social distancing, doesn't mention basic procedures, at least as I understand them. I would come back to you and I would say, here is the government's statement. Here's the government's declaration. Please read it carefully. And now answer the question whether or not the protocols that they have described here meet professional standards for addressing this particular virus. So you don't have to repeat everything you said before. You just answer a discrete question that has come up in the course of the litigation.
Great. I want to just touch upon, we have 10 minutes and a couple more questions, but very briefly, what are your professional expectations from this partnership between doctors and lawyers? Anything that you want to share about communicating with one another, about timeliness and deadlines, and also importantly, what if you're offered, so in some cases I was offered to be paid. Is that something that a lot of people do, or does that somehow impact my credibility if I decide to take the money?
All right, I can break that down into two questions. These cases, until the government gets into compliance, until the ICE and other law enforcement get into compliance with the CDC and with professional standards, we're going to keep bringing these cases. The ICE does not get an exemption from the same sorts of directives that everyone else on the planet is required to follow. And we're going to keep coming to you for help in terms of stating what the appropriate standards are. If these cases are appealed, if they move up, I'll also come back to you and I'll say, we would also like an amicus brief on behalf of epidemiologists, on behalf of every respected society and organization that addresses these issues. And either those organizations will have lawyers, or there are lawyers that are chomping on the bit to address those questions in all sorts of areas. I worked on the DACA case in the Supreme Court. There was a whole slew of very powerful amicus briefs talking about the consequences of the rescission of DACA. So we need you now for those declarations. We may need you very shortly. And don't wait for us, to the extent that other societies, organizations, physicians, epidemiologists, scientists that can help out. Those are lists that we want. That's partially an answer to your prior question. In terms of payment, the organizations that do this work, the public interest organizations that do that work, we don't have money to pay you what you would otherwise charge. But would it impugn if you got payment from a particular set of law firms or lawyers? No, I don't think so. As I said, I just think, I think it is meaningful that you're not charging. Do I think it impugns the integrity of what you're doing? No, and you're putting an enormous amount of time, and you're not doing it to buy a limousine. You're doing it to help the organization and to do other things. So I don't really worry about those things. I mean, I see, if I see an expert making $100,000 on a particular case, I think, what's going on here? And I worry about opinions for sale. But not you guys. You guys are the best, and I'm not worried about that. Sometimes experts will say to me, Mark, I would like to have a few graduate students do some research for me, which I will personally supervise and check. And they may need grad student rates to do that. And, that I typically can find the money for that. So, but don't let anything stand in your way of providing this testimony.
Mark, I'm going to read another question that sort of is linked to what you mentioned just a couple of minutes ago about an amicus brief. So the question is, if an amicus brief is a legal document, how should amici with non-legal backgrounds, such as physicians, approach writing an amicus brief?
Good question. You should work with a lawyer. Some amicus briefs, the most famous amicus brief in the history of the Supreme Court was associated with Brown versus Board of Education. And Kenneth Clark from New York wrote about a study with respect to the impact of segregation. It was not written in lawyer language. You need a lawyer to help format it. You need a lawyer to help get the matters filed in court. But it may well be that it will be a a longer analysis of what the issues are. And you should write that in your language, not a lawyer language. So you need lawyers to help you shepherd it through. But in most instances, you working with a lawyer will be sufficient, and your writing, your expertise will be sufficient. I find those to be the best amicus briefs in terms of actually having an impact on a court.
Mark, what about, again, process in terms of turnaround time? When you approach somebody, is there an average turnaround time? I know when I worked with you, it was basically from one day to the next. Is that always the case?
It's frequently the case. We're in an emergency. The technical term is a temporary restraining order. That means things have to happen like this, because if they don't, then people could die. And so the deadlines may be very, very short. And I told you those deadlines at the beginning, and you asked me what those deadlines would be. As the case stretches out a little bit, the deadlines lengthen, and there will be more time. But in the first instance, it can be very, very quick. Now, we have a preliminary injunction, which is the next stage, and we have 3 days, which is a lot better than 3 hours. And if it goes on appeal, we'll have a few more days than that. But I don't want to mislead anybody. The turnaround time can be very quick.
And are there situations in which the judge may want to speak to the medical expert? Is there testimony? How does that work?
Yeah. I always hope that the answer to that is yes. My first hope is that, the judge doesn't need to. But, the first thing I said to you was, one of the first things I said to you was, look, we'll submit the declarations. I think they'll be sufficient. But can I tell the judge, since it's an emergency, that you might be available to talk to the judge? It's a him, to talk to him about it. So it's rare. I'm not aware of any of the current cases where that has happened. But I like to represent to the judge that you might be available. And the other side, they can ask you questions as well. So it's exceedingly rare, but with life or death consequences, a court may want to be able to talk to you. And so, you should give the lawyer your availability if the lawyer doesn't ask for it in the first place.
Great. We're almost out of time. Mark, any final parting thoughts before we?
We need you so much. Like I said, we have incredibly brave clients, but you're the backbone of these cases. A first-year law student could do the legal work I do. The important thing is your statements. So having access to you, having a list of your participants and the participants they know, it's going to make all the difference. And if you have questions or the participants have questions, you can email me, you can give out my cell phone number, you can call me anytime. We really need you badly, and we're privileged to be able to partner with you.
Thank you so, so much. You've been incredibly helpful to me personally, and I hope that some of your wisdom and experience is going to benefit the people who joined. I wanted to say that, first of all, Physicians for Human Rights is also a resource for many of you, and we're happy to connect you with lawyers working around the country. Right now, we've been involved in about 15 declarations in different states, so always need more people, as Mark was saying. And we will also, in the next day or so, circulate some templates for declarations and sort of sample declarations so that you can look at, and of course do not cut and paste, but use it as a means of drafting something that is your own. And if you have any questions, you know how to find us. I wanted to thank Mark again. Thank you so much for your expertise. Thank you to Catherine for being our fearless leader at PHR on all things detention and asylum. And thank you, everybody, for tuning in. And please stay in touch, and we're happy to help, and we're happy to make those connections with Mark and other lawyers around the country.
All right. Stay well, everybody. Thanks for including me.
And stay healthy, stay home if you can. I know many of you work in hospitals and clinics, but hopefully everybody will weather this crisis and will come out on the other side stronger and wiser.
Thanks very much.
Thank you so much. Thanks, everybody.
Thanks so much to our wonderful panelists for your amazing expertise, and thanks to everyone who's